Good afternoon, everybody. I want to talk about an interesting new case that came down here just recently, and it's about some raw sewage that ended up backing up into a commercial space, and the court was trying to decide who was liable for it. And the specific legal issue that was on appeal was whether the association that operated the commercial building, whether it was negligent, or which means they breached their duty of care, or did they breach the contract by not providing a proper lift station for the sewage. And so you've got, in lawsuits, a lot of times we have multiple legal theories. So in this case, the plaintiff said, I've got a legal theory for negligence, and I've got another legal theory for breach of contract, and those are two different standards. So what the court was trying to decide is, if the owners were not negligent, they did what they were supposed to, they acted reasonably, they acted prudently, so they were not guilty on that. But then the trial court said, but even though they weren't negligent in their duty of care, they still could breach the contract, because the contract had this one very interesting provision in it, just a few words that I think would get missed in a normal reading of these kind of declarations. So these are covenants, conditions, and declarations, typical for a homeowners association, also typical in commercial spaces where you've got a lot of users depending on the developer to provide, certain things at the development site. So these development standards, covenants, and restrictions said that the lift station would be maintained in, quote, continuous operation. So the trial court said, and the Court of Appeals agreed, that those two words, continuous operation, was really a contract between the owner of the property and the tenant in this situation that brought the lawsuit to guarantee, in strict liability, guarantee as a contract matter, that they would always provide a lift station, even if what they did was reasonable, right? Legal theory number one, negligence, and then legal theory number two, contract. So the court says you broke the contract because your contract says continuous operation, and even though you behaved as a prudent landlord or as a prudent property owner, you still violated this. Now, I want to put this in context because there's a lot of litigation that we do with HOAs or with commercial centers, and we always present multiple legal theories. So as a participant in those kind of things, and when you review your contracts and the CCRs, when you go into a commercial site or you buy into a subdivision, you really need to look at those covenants and see what they say. And there's some very strict liability provisions in there, and that's what the courts are going to find. And this even, I think, is going to bleed over to, or have an effect, not bleed over, but it's going to have an effect over here with construction cases. Because a lot of times in construction cases, the legal issue is whether or not you provided workmanlike services. Did your work, was it to a reasonable standard of care in the industry and that kind of a thing? And so that's going to be very parallel to this, situation that we've got in this case, where you've got a negligence theory, a workmanlike conduct. You might have been workmanlike, but you may also break the contract anyway because you didn't fulfill what you promised in your contract. So I think that there's a lot of applications here, and there's a huge percentage of real estate that is governed by CCRs, covenants, conditions, and restrictions, both on the commercial and residential level. So very important case, and a very important distinction to understand when we file lawsuits or we defend them. You've got to be very careful that you can win on one but lose on a different one. So you got to be careful with that and understand it with your counsel. So we'd love to help you with it. I gave you the citation on this so you can read the case yourself and see what all was involved in it. But it's pretty straightforward. And the court just said, look, there's two different legal theories here and there's two different standards. So be careful. Thanks very much and have a great day.